briefing from Ms. Adams.
Good morning. House Bill 1492 addresses implementation of the 2021 State v. Blake decision, which held that the strict liability crime of simple possession of a controlled substance is unconstitutional. The ruling in Blake applies retroactively, and as a result, all convictions under the statute are void going back to its original enactment in 1971, and all persons convicted of the offense are entitled to have their convictions vacated. There is no automatic process for vacating the convictions. For each conviction, a motion must be brought in the sentencing court to vacate the conviction and refund any LFOs or legal financial obligations that were paid as a result of the conviction. In the interest of time, I'm just going to jump straight to an overview of the bill. House Bill 1492 establishes standard procedures and requirements for vacating convictions, resentencing persons, and refunding LFOs pursuant to the Blake ruling. It sets forth the qualifying convictions that are eligible for vacation and the LFOs that are subject to reimbursement for a person who has either a qualifying conviction or who paid LFOs as part or as the result of a qualifying non-conviction. That's a qualifying offense where charges were not filed or were dismissed pursuant to a diversion, a deferred prosecution, or completion of a therapeutic court program. So the main components of the bill are that the Administrative Office of the Courts is directed to work with clerks to prepare reports for every court of all persons with qualifying convictions or qualifying non-convictions, prioritizing those cases where the person is incarcerated or under supervision due to a qualifying conviction. Based on these reports, prosecuting attorneys must file ex parte orders or, ex parte motions with the applicable sentencing court to dismiss and vacate each qualifying conviction, and for the refund of LFOs paid under any qualifying non-conviction. Prosecutors must file quarterly status reports on these filed motions and complete this work by January 1st, 2026. Regardless of whether a prosecutor is expected to file a motion, a person may file their own motion with the court for a vacation of a qualifying conviction or refund of LFOs. And there are specific requirements that are established where a person may be entitled to resentencing as a result of a qualifying conviction. A prosecuting attorney may not refile any charges for acts alleged in the original charge for the vacated conviction or for a conviction for which the person qualifies for resentencing. With respect to legal financial obligations, the bill establishes standards for determining LFO amounts that are entitled to be refunded, including when there may be more than one conviction under the cause number that includes non-qualifying convictions. When a court orders a refund of LFOs, the court must direct the clerk to cancel any unpaid balances, provide the court with an itemized and totaled amount, direct the clerk to certify that these amounts, and order the administrative office of the courts to refund those certified amounts. A person has the right to challenge the amount of any LFO refund ordered by a court and the right to assistance of counsel in reviewing the amount and bringing a motion to amend the refund amount. LFOs ordered refunded must not be reallocated to any other LFOs. The person is required to pay under other cause numbers or for other convictions under the same cause number. And lastly, the AOC is directed to establish and administer a refund bureau to provide direct refunds to people entitled to LFO refunds, and to provide notice to persons of their right to a refund and the process for applying it. And I'll just note that the AOC, pursuant to the budget and funding provided in the budget, was directed to begin work on this, so they are in the process of creating this refund bureau. With that, I will conclude my remarks.
Thank you. Questions for staff? All right. Vice Chair Simmons, welcome back. Tell us about your bill. Thank you to the best chair in the legislature, my seatmate, for the record, and thank you to Ranking Member Walsh and Vice Chair Farivar and all of my fellow colleagues here. For the record, I'm Representative Tarra Simmons from the 23rd Legislative District. And this bill is about refunding the legal financial obligations of people who were convicted under Blake and vacating those records. In February of 2021, when the Blake decision came down, I was the only member here that actually had a Blake conviction. And I'm also the founder of a nonprofit organization that works to help people vacate their criminal records so they can move forward and find employment and housing. And as a lawyer, I was probably the first person in the state to file to motion to vacate my Blake conviction right after the decision. It took over a year to get my refund of my legal financial obligations. And when I did get that, it didn't include any statement of the summary of what I was being repaid for. So I mistakenly believed I wasn't getting my interest back, but I found out after communication that I did actually not have interest because it was waived. While other members in the legislature are more concerned about the drug policy going forward and whether we're going to give people criminal records again, I've been really focused on helping the estimated 262,000 cases get cleared up. And that's because I really care about workforce development, and that's a priority for this session, I believe, is to help people get into jobs. A lot of these people are held out of jobs. They have a Blake conviction from 10 years ago and can't be a certified nursing assistant or something like that. So I really care about that issue. So to date, we have only cleared out about 43,000 of these cases. That's 2 years, and only about 43,000 of the cases have been cleared out. During committee assembly days, there was a great presentation. I went back and watched it again last night to this committee where OPD, OCLA, and AOC asked for direction. And AOC is particularly needing direction at this time because their refund bureau will start processing refunds on July 1st of this year. So this bill really should get through before they start processing. And that's because the problem is they don't have a good definition of what is included in a legal financial obligation. Does that include the drug court costs that people paid even if they weren't convicted? Does it include, there's a variety of different legal financial obligations that people paid. And the other problem is we don't have a unified process of how people are doing this in different counties. And some examples are not all jurisdictions include language to protect against deportation. So people that were convicted of a Blake conviction do face deportation if they're undocumented. But if they have protective language that this was a constitutional issue, they won't. And if that's not in the order, then people that are undocumented are still at risk of deportation. All counties are doing that differently. Some counties refund all of the money, some do not. Some reallocate the money that people paid on these Blake convictions to maybe other court cases that they might have. Some counties prevent people from vacating these by threatening a new crime. Say somebody had a possession, but they also had a possession of marijuana or a possession of paraphernalia or something. They might say, well, if you vacate this, I'll charge this. And they also, the counties vary on what convictions they will vacate. Some will vacate attempt to possess or possession of marijuana, and others won't. And so the problem is that the practical effect this is going to have is that cases, as these cases go through the courts, the entities, the clerks and the AOC Refund Bureau are going to have to go back and re-vacate or reallocate or do the refunds. And so this bill is really trying to create efficiency in our government to save a lot of money in the future. And so the bill is not perfected. However, all of the stakeholders are having productive conversations and working together, and we are, I think, very close to refining this bill to a point where we'll have a few policy disagreements, but and that's what we can decide as a legislature. I also just want to acknowledge Edie from OPR, who has spent a lot of time working on this bill, and I thank you so much, Edie, for your hard work.
Indeed. Thank you, Madam Prime Sponsor. A question for the Prime Sponsor? Okay, let's hear some public testimony. Madam Vice Chair. Thank you, Mr. Chair. We will start with a hybrid panel with Grace O'Connor and Allie Homan, and remote will be Lisa Henderson. On deck, we'll have Sharon Swanson, and I'll call the following panel after that, which is Russell Brown, Juliana Rowe, and Candace Bach. Thank you.
Right, and we know discussions are ongoing, but we'll start you at a minute 30 as we did for the last bill, and let's hope we can get through everyone. Please.
Thank you, Chair Hansen, Ranking Member Walsh, and members of the committee. My name is Grace O'Connor, and I'm testifying on behalf of the Washington State Office of Public Defense in favor of HB 1492. We understand the concerns of some of our partners about implementation, and we're eager to continue discussions towards workable solutions, and we thank our partners and the prime sponsor for continued collaboration. OPD has been supporting the public defense response to State v. Blake for almost 2 years. We have a bird's eye view of procedures around the state. We know the process for vacates and the scope of relief varies for Blake-affected people from county to county. These inconsistencies necessitate defenders and civil legal aid attorneys to ensure full relief at a cost to efficiency. HB 1492 course corrects and reflects the lessons learned over the past 2 years. The bill takes the burden off the affected person to come forward and jumpstarts the vacate process. Many counties already operate in this way, though almost as many do not. And because the bill makes clear the scope of relief, it ensures equitable outcomes in a prosecutor-led effort, decreasing the need for defenders to be involved in vacates. At the same time, HB 1492 preserves a right to counsel where there may have been omissions or mistakes and in the context of resentencing. OPD is equipped to handle its responsibilities under the bill. The mechanisms we already have in place for supporting county-level defense will translate well into the service models contemplated under the bill. We look forward to continued discussion with our partners and again, thank the prime sponsor.
Right, please.
Good morning, Mr. Chair Hansen, Ranking Member, and members of the committee. I am Allie Homan, and I'm here today on behalf of Washington Defender Association, where I serve as the Director of Legal Services, where we support training and technical assistance of public defenders in all 39 counties in the state. And we also, along with the Washington Association of Criminal Defense Lawyers. I am here today in strong support of House Bill 1492 because today we have the gift of hindsight. We rarely have that in the law. And what this hindsight is telling us is that we know that the courts, all 39 superior courts, had to scramble, and we all worked together. It was very collaborative, and I really want to acknowledge DOC. I also want to acknowledge WAPA, OPD. We all came together, the Superior Court Judges Association, to figure out how the heck do we process all these cases, because lawyers are not good at math. I will own that on the record. But what we found is that we still had the problem of justice by geography. So where you live determines if you get justice or not, or how fast. And justice delayed is justice denied. We also know that there's a disproportionate impact to BIPOC, Latino, Latinx populations, and other communities that are indigent that have been impacted by this. This would provide, no matter where you live, you know when you're going to get that much needed money as we all struggle with inflation and higher cost. Finally, the law is settled around LFOs. Nelson v. Colorado, the U.S. Supreme Court with that said that money that the state with exonerations is owed to the defendants. With that, we respectfully request that you vote yes on HB 1492. Thank you.
Right, let's hear remotely from Lisa Henderson, please.
Good morning, Chair Hansen and members of the committee. For the record, my name is Lisa Henderson. I'm the San Juan County Clerk and co-chair of legislation for the Washington Association of County Clerks. I am testifying on behalf of the county clerks as others on this bill. We do have concerns regarding the expansion of the definition of LFOs. We believe we have a definition, as well as the expansion of charges that are eligible under this legislation. Some counties have completed this work and exhausted any appropriations that were allowed in the previous session. In regard to reporting requirements on the bill, the clerk can provide reports only for data that is in our records or fees paid through our offices. We cannot provide or certify any other agency costs or information that is not specifically in our records, as is outlined in this bill for third-party agencies. We are concerned with the language that removes fees proportionally dependent on what charges are on the case, simply because this is going to be when you're talking about prorated basis, this becomes a monumental task. Finally, as we're thinking about reallocation aspects, some counties have reallocated based on court orders, and we had the authority to do so. Money was reallocated to non-Blake impacted cases. Under the current language, counties could not seek reimbursement because they are not impacted. But these cases that we reallocated to were not impacted by Blake. And we would leave counties holding the bag, and that might be considered a gift of public funds. Finally, the language directing clerks to cancel unpaid balances identified in previous sections. Again, we cannot fully comply with that because we don't have that information. We can't certify or waive things that are not in our purview. Thank you for the opportunity, and we look forward to working with the sponsor on further revisions to this bill.
Thank you. Sharon Swanson, please.
Thank you. Chair Hansen, Ranking Member Walsh, members of the committee. Sharon Swanson, testifying on behalf of the Administrative Office of the Courts. We have signed in as other. We are neutral on the policy discussions in the bill. I am here merely to highlight some technical concerns and questions. First, I want to thank the prime sponsor. As you've heard, there's been a very robust stakeholdering process, and we are looking forward to continuing to work with the prime sponsor and the other stakeholders. Some concerns about how we can implement, you just heard from the clerks about the private entity and information that exists outside of the court system. Thus far, AOC's process has been to refund amounts that are either included in a signed court order from a judge or that have been certified by a clerk. So once we start talking about LFOs with the information that exists outside of the court process, that heightens our concerns about fraud and our ability to document accurately where the information came from and how it's been relied upon. So I won't talk about the private entities, which you just heard about, but I will reflect LFOs in the legislation also. It talks about information that doesn't exist in the courts. It exists currently in Department of Corrections. So when we talk about refunding for the costs of supervision or incarceration, we are not sure how the information is going to come from the Department of Corrections to within the jurisdictions of the courts. So we need to figure out how we're going to address that. Additionally, there's a few other concerns. One, the legislation talks about assistance of counsel. We are not sure if that means we're appointing counsel, whether or not we need to implement indigency standards. So we need a little more clarification there. And we would ask for some sideboards around the ability of a person to appeal the refund amount of their LFO. We need to have a mechanism so that if AOC is processing their refund and at the same time the individual is appealing that amount in a court, we need to make sure that we are aware of that. We're getting very close. We, again, thank the prime sponsor for all of her efforts, and we continue to be involved in the process. Thank you.
Thank you. Further public testimony, Madam Vice Chair.
Thank you, Mr. Chair. We'll now call up Russell Brown, Juliana Rowe, Candace Bach, and Julie Barrett will be remote. After that, we'll have a final remote panel of Scott Ketterling, Teresa Groves, Camarina Zoruza, and Brooke Hagara.
Good morning, Mr. Chair, members of the committee. My name is Russell Brown. I'm the Executive Director for the Washington Association of Prosecuting Attorneys. I am here testifying with concerns on House Bill 1492. I appreciate the intent, and I agree with the policy desire, which is to streamline and make this more cost-effective and efficient. I also concur that there have been over 40,000 vacates, and that's an enormous amount of work. Our concerns lie in a few things. Number one, as you've heard, there's an expansion of what we believe the definition of LFO should be. And part of that expansion includes private entities or individuals who will have received money that the courts will have no ability to determine. Right now, prosecutors are required to work with the clerks to find that information. And we don't believe that that's feasible or possible. And if required, will require an enormous amount of additional work for individuals who aren't necessarily the best equipped to find that information. There's also an expansion of the number of cases that expand beyond what we believe Blake includes. We also question whether this body has the ability to determine that particular cases a court hasn't decided to be unconstitutional now could be unconstitutional. There also are additional Oh, my time is up. So I've provided written feedback. I'm happy to share that with anyone here if they want.
No, we'll read it. Thank you. Please.
Good morning, Rep. Hansen, members of the committee. Juliana Rowe here on behalf of the Washington State Association of Counties, also testifying with concerns this morning. You've heard a lot of comments from others that I totally agree with. Since Blake was decided, we have worked diligently, the entire court system, to get these through. And 43,000 cases that have been vacated is a monumental accomplishment. And we still have a lot of work to do, but these, excuse me, we were creating an entirely new process and with all sorts of folks involved and working with a court system that was already backlogged due to a variety of reasons. We're working through the pandemic, which further backlogged the courts. And so I think that we are doing the best that we can with what we have. But as Russ stated, the bill expands the scope of Blake, both in the types of cases and the class of people going back to 1951, but also the types of LFOs that qualify under this bill. It will not only be costly to go back and revisit all of these cases that we've already gone through, but also further backlog a system that is struggling to get back on track. And so we would ask that if you decide to pass this, that you make it subject to appropriation and provide additional funding for our counties and the court system to accomplish this task. Thank you.
Thank you. Please.
Thank you, Chair, members of the committee. Candace Bach, representing the Association of Washington Cities here, also with concerns, again, echoing much of what my colleagues have said. I think in the case of Blake, sometimes there's, not that we're completely forgotten, but there's sort of, the focus is on district or superior court, but this did impact our municipal courts as well, and thank you to the legislature for providing funding last session to help with repayment of LFOs that were part of the municipal court system. And those contracts just got in place last fall with the hard work of AOC and our municipal courts. So that process is moving forward, and those repayments and those vacations are happening at the municipal court level. As you heard, our concerns are that this is more expansive than just Blake, capturing more misdemeanor charges that are not necessarily funded at this point through those dollars that were provided last session. And this could make for, again, more work and complicating without really the necessary clarification that our municipal courts need to adequately address the Blake LFO situation. Thank you.
Thank you. Representative Cheney has a question, please.
Thank you, Mr. Chair. This question is for Mr. Brown. As I understand it, this would require vacation of any pendent escape charges, unlawful possession of firearm charges, anything else that might have been a subsequent offense if the person didn't have those restrictions, say a firearm restriction from a previous offense. Is it fair to say that if that is the way this bill is intended to be, is to vacate all of those subsequent convictions, you would then have to come back into court for any subsequent conviction to that to recalculate the offender score? Am I interpreting that correctly? This is a waterfall, a very wide waterfall of secondary and third order effects. Is that correct?
I think that is correct, Representative Cheney, and I think for the cases that are currently being vacated, for example, for simple possession, it does create that waterfall, and those are cases that are being worked through. The concern here would be, as you indicate, that there are cases that fall outside of that scope that are being added to that process. And yes, then it's not just the single case, it's the cases that then flow from that. And so, and again, you multiply that by 240,000 cases, that workload expands greatly.
Great, thank you. Let's hear from Julie Barrett remotely, please.
Good morning. Can you hear me?
You can.
Perfect. Good morning, Chair Hansen, Ranking Member Walsh, and members of the committee. Thank you for allowing me the opportunity to testify before you this morning. I'm Julie Barrett, founder of Conservative Ladies of Washington and a resident of the 44th District, testifying today in opposition to House Bill 1492. This bill creates a lot of policy and procedural concerns that are not addressed in the text of the bill. This would create not only a substantial increase in workload for our courts, clerks, and prosecutors across the state, but would also have significant financial ramifications. With the passage of this bill, we would have to create and administer a refund bureau and a searchable database to allow persons to see if they are owed monies. Then the clerk's office would also be responsible to locate and send notices to these convicted offenders as well. Where would the money that this bill deems as owed to these people come from, assuming that these fines and fees were already spent to cover the costs incurred? The taxpayers, of course. In addition to refunding these monies, we have a new payroll and staffing issues to address. Do our courts currently have staff that can take on this additional workload? This would undoubtedly create an even greater backlog in the prosecutor's office across the state as well. A bill like this would create a huge new system within our courts, and we would like to see input and collaboration on the proposed legislation like this from our court system, clerks, and prosecutors around the state. Given these concerns, we would ask that you do not vote this bill out of committee. Thank you.
Thank you. Let's hear Scott Ketterling, please.
Good morning, Chair Hansen and members of the committee. My name is Scott Ketterling. I'm an attorney, and I'm testifying today on behalf of the King County Department of Public Defense in support of HB 1492. Since the State v. Blake decision, counties and courts across the state have varied dramatically in their response to the enormous amount of work that must be accomplished under this ruling. The threads of drug prosecution have been woven into almost every aspect of the criminal court system, and unraveling this has been daunting. This bill would clarify many unanswered questions, provide explicit direction to criminal system actors, and create a more equitable and consistent response across Washington to the Blake decision. For example, sections of this bill would clarify what specific crimes should be vacated, who is entitled to resentencing, and what specific financial obligations are owed. Disputes over these issues have delayed progress in this work, wasted Blake funds, and consumed limited system resources. Finally, I'd like to emphasize the importance of accomplishing this work without delay. The drug war over the last 30 years has disproportionately targeted the most disenfranchised, including BIPOC communities and those already suffering with mental health and substance abuse issues. These void criminal convictions continue to inflict harm daily to those individuals and their families through the denial of access to housing, employment opportunities, and education funding. This bill would move the entire state forward in accomplishing this important work. In sum, there's a tremendous amount of work that must be done across the state to mitigate the harm of these unconstitutional convictions. This bill is a step forward in providing a framework to achieve that goal, so I urge you to move it forward. Thank you.
Thank you. Let's hear from Teresa Groves, please.
Good morning. My name is Teresa Groves. I'm here to testify in support of the bill. I'm a staff attorney at Civil Survival Project, representing indigent clients in obtaining Blake relief and providing self-help for people who want to try to obtain relief on their own. I've worked on Blake cases in dozens of counties and municipalities throughout the state. Every single one of them has its own process and wildly different understandings of which LFOs are affected. For example, in a recent case, a prosecutor prepared an order vacating my client's conviction for simple possession, but did not address LFOs, even though the prosecutor agreed the LFOs should be refunded. The prosecutor insisted the clerk would automatically know to refund those, but after the order was entered, the clerk told me she's unable to refund any LFO on the basis of that order. The end result is more litigation, which consumes the time of all parties involved. More importantly, it delays the justice to which my clients are entitled under Nelson v. Colorado and the refunds they desperately need. In the current landscape, obtaining relief is difficult and cumbersome for me, and I've been practicing law for 13 years. It's near impossible for non-lawyers to navigate when they try to obtain this constitutionally mandated relief on their own. House Bill 1492 addresses those problems, and I urge you to pass it.
Thank you. Can we hear from Camarina Zorozua, please?
Good morning. Camarina Zorozua, co-founder and legal director at The Way to Justice. We're a nonprofit civil legal aid organization based in Spokane. We serve justice-impacted individuals in Eastern Washington and across the state. Our mission is to empower communities through advocacy and access. We offer Post-conviction relief through an equity lens to remove barriers to our clients so that we can address the collateral consequences of convictions. This helps our clients access services, housing, employment, and education opportunities without being seen as second-class citizens due to an old charge or conviction that is actually eligible for relief under statute, or in this case, under Blake. We do this by reducing legal fines that they owe, restoring their rights, and vacating convictions. We've vacated State v. Blake convictions in dozens of counties all across the state of Washington and have experienced the inconsistencies. Our work is focused on a holistic model. We center the individual needs of our clients. We have screened every individual who walks through our doors for Blake relief. Many of the people we come in contact with do not know that they have a qualifying case under Blake or that relief is available at all. Through this work, we've seen the harm caused by actually 50 years of the war on drugs, the impact on our clients, their families, their loved ones, and our communities. These harms have been disproportionately felt by people of color, those who have substance use disorders, mental health needs, and those living in poverty or homelessness. Due to the war on drugs, discrimination through policing, the targeting and criminalization of people of color throughout our justice system, bias and discretion given to prosecutors in their powerful positions that result in harsher sentencing, lack of sentencing
I'm
alternatives.
sorry, you're out of
offered or
time, so
available.
you're pro on the bill, right?
For the most part, except for Section 3, we would like to express our concerns regarding ex parte entry of orders that would deprive defendants of notice and the impact that that may have on immigration proceedings in federal courts.
Thank you very much. That will conclude the public testimony and conclude the public hearing on House Bill 1492.